navigate the uncharted waters that we're in through this crisis. First off, I wish you and yours safety and health. We have Mother's Day coming up. I know that's going to be very difficult, certainly very difficult for me. I've been delivering groceries to my parents and looking at them through windows like it's an aquarium or zoo, and it's horrible. On top of that, obviously, so many of our members are suffering economically, tremendous numbers of challenges. The government, from a government's perspective, and this, I'm talking all governments, because one of the things that we can take great pride in, certainly relative to what's happening south of the border, is a tremendous amount of collaboration and cooperation by all. We're continuing to push, and so today we've brought great experts to take you through where we are today with the rent subsidy and wage subsidy issues. The experts, being experts, can only tell you what it is that's there right now. We, being advocates for business, not only want you to have that information, but also need your input so that we continue our advocacy efforts to change and improve the programs that are there to provide the support that we need, that you need, to survive, get past this, and be part of the recovery of the economy. The rent subsidy issue in particular is causing our members enormous pain, enormous frustrations, puts an undue amount of power and responsibility and pressure on landlords to opt in, and a lot of confusion. So let's try to get rid of that confusion today, and let's listen to your questions about how we can continue to push to improve them. And with that, I'd like to hand it over to my colleague, Michelle Eaton, VP of Public Affairs at OCC, to introduce our panelists and moderate the discussion.
Thank you so much, Rocco. It seems like the world continues to change before our eyes with this pandemic unleashing unprecedented disruption on the operations of employers, our healthcare system, and society. And in response, it seems like almost every day, different levels of government are announcing new programs or changes to existing programs to help support people in business during this very difficult time. The Ontario Chamber has been actively advocating for Ontario's business community during this crisis. And what's significant is the willingness of all levels of government to adapt their programs to make sure that they're meeting the needs of people and business. So, but listen, a lot of these programs take months in development. So seeing the government's flexibility during this time is excellent. But it's also challenging for many employers and employees to keep up these programs. How and if they qualify, how they work together. We hear from businesses every day who are feeling overwhelmed and stressed and scared. So, today's conversation will address key questions about some of these programs and how do they apply to businesses across the province. I'm just so delighted we're joined by today's esteemed group of panelists. We have David Ahern from KPMG Canada, Stephanie Kalinowski and David Foster from Hicks Morley. We've received many questions from you in advance, and we'll do our best to address as many of those as possible, but you can also feel free to send me your questions in chat. So without further ado, I'm simply delighted to introduce our first panelist, David Ahern. He's the Senior Vice President in KPMG's Corporate Finance Practice of KPMG's Toronto office. He specializes in corporate debt advisory, providing a range of debt advisory services to corporate clients across both mid and large cap markets. Over to you, David.
Thanks, Michelle. And through the wonders of technology, I'm hopefully will share my screen. And I hope this is. Michelle, can you just confirm that you can see that at your end?
Yep, I can see your slides.
Okay, great. Hi, everyone. It's great to be here to speak to you on this topic, and I know it's quite a relevant topic to everyone on the phone today. So, what I intend to do here is I suppose to kind of lay out the facts as they are today, based on the information that's available on the Commercial Rent Assistance Program, or CIRCA, or CIRCRA as it's been referred to. I will say, just before I get into the slides, that I appreciate there's a lot of frustration out there and confusion as to what's available, when it will be made available. As I said, I'll go over what's the facts that are there as we have today, but we fully expect that there's going to be more clarity and will be delivered on this program over the coming days. So to make things a bit more clear for business owners and landlords alike. So sorry. So overall, so we've got the Canada Emergency Commercial Rent Assistance Program. So what's it there to do? The idea is to provide rent relief for eligible small businesses experiencing financial difficulties arising from the current pandemic. The program is going to offer forgivable loans. I think this is what's a crucial fact in this. It's going to offer forgivable loans to eligible commercial landlords in order to reduce rent owed by their impacted small business tenants by at least 75% for the months of April, May, and June. The program is going to be managed, it's a federal program, but it's going to be managed by the province and territories. And obviously with the Ontario government partnering with the federal government here, and there's over 900 million available to Ontario businesses. What I've done over the next few slides, I have incorporated what's being made available from the federal side, but I've also incorporated what's been made available subsequently from the Ontario provincial government. So the CIRCRA program, from an Ontario point of view, is going to be known as the Ontario CIRCRA program, and I'm just going to call it that for ease for now. And this program is going to be administered by the Canada Mortgage and Housing Corporation, CMHC, and it's going to be available until September 30th for landlords to apply, and again retroactively from April through June 2020. Now, the current information out there is that the program is expected to launch mid-May. However, as I said at the top, there is a number of details that are still to be finalized, including, critically, how funds are actually going to be dispersed and how you can actually apply for the program. So there's two key elements on this. So it's what's a qualifying landlord and what's an eligible business. So to go through, so the current information on a qualifying landlord, obviously it's going to be the owner of a commercial real property that generates rental income, where the small business tenant have been impacted. Under the current definition, the landlord has to have a mortgage loan secured by the commercial real property, where the affected property. The landlord will enter into a rent reduction agreement, including a moratorium on eviction for the period of April, May, and June. That will reduce the impacted small business tenants' rent by at least 75%. Now, the critical thing at the moment, and what's caused a lot of confusion, is the fact that the landlord actually has to have a mortgage loan in place. There's been a lot of feedback already given both at a federal and a provincial level. And while details aren't available at this stage, all indications are that landlords that don't have commercial mortgages will be able to apply under the program. But again, details on this are not available at the moment. So what is an eligible small business? So at the moment it's defined as a business that's not paying rent of more than $50,000 per location. And again, defined by a valid and enforceable lease. The small business generates no more than 20 million in gross annual revenues, and that's calculated on a consolidated basis. Is a non-essential business, and this is something that's defined in the Ontario CIRCA details that have been made available to date, and has either temporarily ceased operation or has experienced at least 70% reduction in pre-COVID-19 revenues. And again, this can be done by either comparing month-over-month revenues versus the same period in 2019, or comparing back to average periods for January and February in 2020. And the Ontario Circuit program specifically excludes any entities that are owned by individuals holding public office, any entities that promote violence, incite hatred, etc., or any entity that is in the special accounts or restructuring group prior to March 1st with their current lender. So I think the effect here is what the Ontario Circuit program is trying to help small businesses that that were financially viable pre this crisis. So how does it work? Now, details are a bit scant on this, and I would say there's also some conflicting information out there at the moment. Under the CMHC guidelines, the loan in place is going to cover 50% of the landlord of the actual rent owed. However, the Ontario Circuit program has gone into a bit more details, and they've said that it's just going to cover 50% of the landlord's profit before costs. So basically, that implies that any landlord that elects to take this program is going to forgo profit for the 3-month period. Now, there is, I think many of you might have seen the article in the Global Mail this morning that said that the provincial government is looking into this, and it may just revert back to the current guidelines by CMHC. But unfortunately, this is some of the lack of clarity that's there. But this is something that we believe will be clarified in the coming days. The loan will be given to the landlord, and it will be forgiven if the landlord complies with all the applicable program terms, including reducing the tenant's monthly rent to 25%, and applying and entering into a moratorium agreement for the 3-month period. And any amounts paid to date by any small businesses for April and May, that money is to be returned by the landlord. Or alternatively, there is ways that landlords and the tenants can enter into a credit program that any monies that were paid in April, if agreed by the tenant and the landlord, could be used against July's rent. That's pretty much it from a high level overview. As I said, there is a lot more information is due to come out, and there's a lot more clarity required, and we expect that to come out over the next I would say 7 to 10 days. Michelle?
Thank you so much, Dave. I really appreciate your insights, and also appreciate that there's only so much information available about this program right now, and more to come. So thank you very much, and really appreciate your time and for you joining us today. Next up, I'm pleased to introduce Stephanie Kalinowski and David Foster from Hicks Morley. As a pension and benefits lawyer in Hicks Morley's Toronto office, Stephanie advises employers, plan administrators, and service providers on all regulatory, governance, compliance, and tax matters affecting pension, retirement, and group benefit plans, as well as incentive plans and compensation matters and cross-border issues. David is a labor and employment lawyer in Hicks Morley's London office. He practices in all areas of labor and employment law, where he provides advice and representation to employers in the public and private sectors on a wide range of issues, such as labor disputes, grievance arbitration, human rights, and accommodation matters and wrongful dismissal claims. Thank you very much for joining us today, Stephanie and David. Over to you. Stephanie and David?
They're still muted.
You'll just have to unmute. I tried moderating unmuted too once. Didn't work out so well.
Sorry about that. It was not so much the mute that was the problem. It was the Zoom window disappeared. So just bear with me while I get the presenter screen back. Okay, so you can hear me and you can see the slideshow at this point, I hope.
That is correct, Stephanie. You are good to go.
Okay, great. Thanks everyone for your patience as we grapple with this new technology. So rent relief, obviously a big question on everybody's minds, but one of the earlier programs that was rolled out by the federal government relates to wage relief. And so clearly everybody has a lot of questions about that and what it means for their business. So we will be focusing on that as well as some of the employment implications of the wage subsidy programs. This all started in March with the catchily named COVID-19 Emergency Response Act #1. And it created what by now you've likely heard about as the CERB, the Canada Emergency Response Benefit, which essentially replaces EI for the immediate pandemic-related period of time. It made some related changes to the Employment Insurance Act, and then it implemented a number of income tax measures, starting with the small business wage subsidy. The small business wage subsidy, as suggested by its title, is only applicable to small businesses, nonprofit organizations, and charities. It's in effect for 3 months. It's in the amount of 10% of the remuneration paid during that period to a maximum of $1,375 per employee and up to $25,000 per employer. And it can be obtained through reducing the source deductions for income tax that would otherwise be remitted to Revenue Canada by that employer in the normal course, but only by reducing the amount related to income tax. The employer would still have to withhold and remit the employer and employee portion of CPP and EI. So it quickly became obvious, I gather, to the federal government that this was not going to be sufficient help for employers to continue paying their employees. So they then moved on fairly quickly, a couple of weeks later, to introduce the Canada Emergency Wage Subsidy, or the CEWS, the CEWS. And so this one was rolled out in early April through the COVID-19 Emergency Response Act #2, and was implemented through amendments to the Income Tax Act. And the reasons that the federal government gave for introducing this was to prevent further job losses and essentially take some pressure off the CERB. The number of people that applied in the first few weeks for EI and then subsequently for the CERB was in the millions. And
sorry to interrupt, Stephanie. It's Michelle here. We've had a couple people asked if you could move closer to maybe to your microphone. Some folks are having trouble hearing you. I don't know if the sound's cutting in and out.
Oh, okay.
Sorry to interrupt.
No problem. Are you hearing me, Michelle, or is it just some people?
It seems like it's fading a little bit in and out.
Okay.
Yeah.
I'll try to hold the microphone close.
It goes the sound different. Yeah. Okay. Great. Thank you.
No problem. So the reasons given for introducing this broader program was essentially to take some pressure off the CERB. Millions of people had applied for EI and the CERB in the first few weeks following the emergency orders and closures. And so what the federal government wanted to do was encourage employers to rehire their workers and put them back on the payroll to maintain that employment connection, so that when things start opening up again, those employers would arguably be in a better position to recall those employees back to work and resume normal operations. So that was the goal. So we'll get into some of the details now about how the CEWS is intended to work. It is in place initially for 12 weeks, and it's through 3 4-week periods starting March 15th and ending on June 6th. However, the legislation does give the government the ability to extend the subsidy by regulation, so they don't have to go back to Parliament for approval, past June 6th to as late as September 30th, 2020. At the moment, we haven't heard anything further about extending the wage subsidy beyond June 6th. And it's hard to say what the government will do. I think it will depend on how the provinces start reopening and what phase they're in as we move through May. Unlike the small business wage subsidy, the CEWS is available to any size of business. And some of you will have seen the news reports about employers like Air Canada, WestJet, Air Transit, very large employers who have who early on indicated their intent to take advantage of the wage subsidy. So it is not specific to any size of employer. It's available to essentially anybody, as long as they are a taxable corporation, an individual, a partnership consisting of eligible employers like taxable corporations or partnerships, and it also includes nonprofit organizations and registered charities. But those employers do have to have a CRA payroll account number as of March 15th. So we have had a few situations where newer employers have asked if they could be eligible for the subsidy. But they were so new that they had not set up a payroll account number by March 15th. And so currently the way the legislation is structured, that will not be possible for them to qualify.
Stephanie, my apologies for interrupting, but I think your headphone is causing the audio to cut in and out. If you could take your headphones off and just use your computer audio, that might be better. It didn't show up when we tested at the beginning, but it's becoming difficult now.
Okay, I will unplug. That's odd. I'm not sure what the problem would be. Okay, you can hear me now?
Perfect, thank you.
Okay, so although the wage subsidy is intended to be available to a broad range of employers, it's not available to all employers. And specifically, public institutions, which is the term used in the legislation, are excluded. So that includes municipalities and entities who perform a function of government, crown corporations, including those owned by a province, wholly owned municipal corporations, as well as public universities, colleges, schools, and hospitals. So really, essentially, if you're an employer in the broader public sector, this wage subsidy will not be available to you. In order to claim the subsidy for an employee, the employee does have to be an eligible employee, which means the employee has to be employed in Canada. They don't have to be a Canadian resident, but they do have to be employed in Canada. It does include new hires. So they've been very explicitly clear about that an employer could bring new people on and claim a subsidy for those people as well. The employee can be working or not working. There's no condition specific to their particular working status, but it is very clear that they cannot have been unpaid for 14 or more consecutive days within the 4-week period for which the subsidy is being claimed. And that is there because of the CERB and the fact that many employees who were initially laid off and went unpaid would have claimed the CERB. They're trying to avoid duplication, although this does not prevent an employer from retroactively putting an employee back on payroll and repaying the individual. I'll talk a little bit more about that in a couple of minutes. So in terms of these claiming periods, the 3 4-week fixed periods, It's March 15th to April 11th, April 12th to May 9th, May 10th to June 6th. And in order to qualify for the wage subsidy, the employer has to demonstrate a decline in its gross revenues during the applicable period. So in order to claim the wage subsidy for the first period, starting March 15th, the employer will have had to experience a 15% decline in gross revenue for March 2020 compared to either March 2019 or the average of its gross revenues in January and February. And then in the second period and the third period, the decline in gross revenue has to be 30%, again, in comparison to the prior period, either April 2019 or May 2019, or the average of January and February 2020. You cannot flip back and forth between your comparison periods. If you choose January and February 2020 as your comparison period, you must continue to use that for all three claiming periods. And the other thing that's quite useful that they introduced was the rule that once you qualify for one period, you're automatically eligible for the second. So for employers who met the 15% decline in gross revenue in March, they will be automatically eligible to claim the subsidy for the April 11th 4-week period. How is gross revenue calculated? It's basically the regular cash receivables and other consideration that the employer earns from its ordinary business activities, but they do have to be ordinary business activities carried on in Canada. And there's a further condition that they must be from arm's length sources, although there is an exception for related employers, which I'll talk about in a moment. It's supposed to exclude revenue from extraordinary items and amounts on account of capital. Gross revenue is to be calculated using the employer's normal accounting method. And the legislation does give the employer the ability to elect, instead of the normal accrual method, to use the cash method instead. But again, once that election is made, it has to be used across all three periods. You can't flip back and forth and use one method or the other for different periods. I mentioned that there were some special rules for related entities. There are organizations that are structured in a way that a particular employer may sell all of its goods to a parent company or affiliate. And so it's the affiliate or parent who sells the goods who's actually itself experiencing the decline in revenue, which in turn then impacts the employer who no longer has the demand coming from that parent or affiliate for those goods and services that would normally be produced. And so an exception was made to that requirement that the gross revenue has to be from arm's length sources to allow an entity that sells substantially all of its products to a related entity to qualify for the wage subsidy. There's a calculation in the legislation that creates an exception that allows them to qualify. And there are some other rules that apply to affiliated groups who can compute revenue on a consolidated basis, et cetera. So the rules are a little bit detailed. There's a few different exceptions there, and we don't have time to get into those today. But if you are in that situation, it's certainly worth understanding those rules and how they apply to you. So then how much can the employer claim as a wage subsidy? You probably heard in the news, roughly speaking, it's intended to be 75% of the amount that the employee was earning before the pandemic started. And to achieve that, they have a greater of calculation. So the calculation itself looks a little bit confusing. It's the greater of 75% of the amount the employer has paid the employee up to $847 a week. And then the lesser of the amount of remuneration paid up to $847 a week, or 75% of the employee's pre-crisis weekly remuneration. What this basically all adds up to is you can return your employees to payroll, pay them 75% of what they were receiving prior to the crisis, and claim up to that 75% with the $847 per week cap. So that's why that calculation looks the way it does. A new employee, of course, would not have any pre-crisis remuneration. So in that case, the greater of calculation doesn't apply, and it's just 75% of up to 75% of the amount that the new employee is paid. That pre-crisis or baseline remuneration is based on the average weekly remuneration paid to the employee during the period January 1st to March 15th, excluding any 7-day periods in respect of which the employee did not receive remuneration. So that's the calculation that's used in order to determine that second part of the calculation, the up to 75% of their pre-crisis remuneration. There's an additional amount that's available to be claimed as well, because certainly bringing employees back onto payroll has other costs, one of which is the cost of employer contributions to CPP, EI, and for employees in Quebec, QPP and QPIP. So the subsidy allows the employer to also claim through the subsidy application a refund of the employer portion of EI and CPP for employees who are not working during the period. So the refund does not apply to those employees who are still working. The employer will still have to pay the employer portions of CPP and EI for them, but it does add some additional relief for those employees who are still essentially on layoff and not able to work during this time, but who will be paid through the subsidy program. The eligible remuneration that counts towards the calculation of the wage subsidy is not surprisingly your typical salary, wages, and commissions, the types of things that are subject to tax withholding in the normal course. That does include some taxable benefits that are paid. A good obvious example of a taxable benefit that might be captured would be a taxable car allowance, for example, where an employee is given a flat rate per month in order to help pay for their personal use of their car, their use of their personal car for business purposes. But it is explicit that the eligible remuneration does not include things like severance, which would be a retiring allowance, the stock option taxable benefits, and although it's not in the legislation, the government's publications have specified that the standby charge for personal use of a corporate vehicle would not be included in eligible remuneration as well. I mentioned that an employee cannot be without remuneration from the employer for 14 days within that 4-week wage subsidy claiming period. So that is because of the interaction of the subsidy with the CERB. Originally, when the wage subsidy was announced, the government had said an employer would not be able to claim the wage subsidy if the employee had received the CERB. And that created some problems because with the timing of the legislation for the wage subsidy and the application not being out until April 27th, it would have really interfered with the purpose of the legislation, which was to allow employers to bring employees back on payroll. So they changed the rule And it essentially allows the employer to bring the employee back on payroll, retroactively pay them back as far as March 15th, or whenever they were laid off, and claim the subsidy. It's the employee's responsibility, if the employee had applied for the CERB, to pay to repay the CERB. If an employee is repaid, the government has said it's the employee's responsibility to repay the CERB, not the employer's responsibility. So as long as the employer has gone back and paid the employee in a way to ensure that the employee doesn't have that 14 consecutive days unpaid, then the employer can pay the wage, can claim the wage subsidy for that period. Some employers will be eligible for both the 10% wage subsidy and the larger CEWS. That is fine. That employer can apply for both, but essentially any benefit they derive from the 10% wage subsidy would have to be subtracted and will reduce the subsidy claimed under the CEWS. Also, if an employer is on a work sharing arrangement with employment insurance, the employer is not precluded from applying for the wage subsidy for the employees who are participating in the work sharing program, but the employment insurance benefits that those employees receive through work sharing will have to be deducted from the subsidy. And very quickly, a few other mechanical issues. The wage subsidy will be considered government assistance to that employer, and therefore would be included in the employer's taxable income. So that is something, if you're considering applying for the wage subsidy, you'll want to understand how it will affect your business or corporate tax returns. In terms of the application process, that was, as I mentioned, released last Monday, April 27th, and businesses can apply through either the CRA My Business Account portal or the WebsForm application. There is an online calculator available on the Canada Revenue Agency's website to allow you to go through and input various information to determine how much you might be able to receive through the wage subsidy. It is an application process that's specific to each 4-week period. So you don't apply once, and for all 3 periods, you will have to apply at the end of each 4-week period. And you have until October 2020 to apply. There is a form that has to be completed by the person who is the individual who has the principal responsibility for the financial activities of the employer. So that might be a CFO, for example. And that person will verify through that form that the application is complete and accurate, and will confirm any elections that have been made. An authorized representative of the employer, like an accountant, for example, or a tax lawyer, could complete the application, but not the attestation. That can only be completed by the employer's representative, the employer's financial internal employee representative. Now, what's interesting, when the application was released, we were expecting, based on what the government had announced, to see a statement on the application that talks about topping up the employees' salaries. That attestation is not in the application. So although the government still maintains that it expects employers to use best efforts to top up their salaries, the employees' salaries above the wage subsidy to their normal salaries, there is no actual attestation on the application about that at all. So that was a bit of a surprise. It's very important that as part of this process that employers keep records of all the wages that they were paid, how they determined the decline in gross revenue, records of the revenue, and we think it's appropriate to still show that an analysis of whether the employer could top up or not was completed. So keeping records will be very important. We do expect that the CRA will be doing a variety of different kinds of audits after the fact to ensure that businesses were not claiming subsidies to which they were not entitled. And related to that, there are a number of anti-avoidance measures in the legislation and penalties to try to ensure that employers continue to be honest through this process, given the amount of money that's flowing out to them. So for example, there's an anti-avoidance provision related to using an artificial transaction to try to make it look like your gross revenue has declined in order to claim the subsidy. There's a 25% penalty plus repayment of the subsidy if you're caught engaging in one of those transactions. There's a 50% penalty associated with gross negligence, in other words, making negligent statements on the application. And there's also, if an application is fraudulent, there's the possibility of fines or imprisonment. There's also some anti-avoidance provisions preventing employers from entering into arrangements with their employees to artificially increase their remuneration during the period covered by the subsidy and then reducing it later in order to try to make the amount of the subsidy claimed larger. So you're not able to come to some kind of strange agreement with your employee where you say, well, we'll pay you more now, which will allow us to claim more of the subsidy, but later, then we'll drop your earnings back down. Wink, wink, nudge, nudge. So that is clearly also not permitted. So that is in a bit of a whirlwind tour of how the wage subsidy is intended to operate. I'm going to turn it over to David now, who will talk about some of the implications that will have for you in your workforce planning.
Thanks, Stephanie. Yeah, so I just wanted to spend a few minutes talking about some of the practical considerations for the use of the wage subsidy and some of the issues that we've been seeing arising from it so far. And basically what we've seen so far are two ways in which qualifying employers are taking advantage of the subsidy. The first is to bring employees back or keep employees on where the financial reality would otherwise require layoffs. And the second case is where we see employers providing a form of paid leaves to employees, even where there is no work for them. And in doing so, they're avoiding the need for a layoff. Can we jump to the next slide? Can you change the slide there, Stephanie?
Yeah, I am trying to, David. I'm not sure why it's not there.
Okay. So as we're all aware, these are unique and challenging times. We have businesses that have been ordered to close. We have others that haven't, but because of the economic impacts overall, there's a need to either fully or partially close, and there's accompanying layoffs. Now, some employers have kept people on payroll, hoping to wait out the crisis. Others haven't had that flexibility and have already instituted layoffs, either part or all of their workforce. And it's that later group that I want to talk about a little bit, how it impacts those who've already instituted layoffs or would otherwise need to implement layoffs in the near future. Can we go to the next slide? Now, in cases where we've already implemented layoffs, many employers are now considering recalling employees to payroll if they qualify for the wage subsidy. And this is happening even if there isn't sufficient work for full-time hours, but with the wage subsidy, it might be feasible to start some productive work to ensure the business can be ramped back up for when the restrictions are finally eased. And depending on the business's financial situation, we're seeing this either occur at the pre-crisis wages or in some cases at a reduced salary. And Stephanie kind of touched on that a little bit with the different calculation methods and obligations. In some other cases, we might not have work for employees because of full closure or just because of the volume not coming in. But that doesn't mean that the subsidy is still not a useful tool. Continuing the salary of employees who are otherwise not working is an option. Again, we can do that either at the pre-crisis wage or at some other reduced salary. And that includes limiting that pay to the 75% subsidy that's received based on those pre-crisis wages. In both cases, employees stay on the payroll, and as a result, layoffs are avoided. One of the benefits to this approach is we're not running the clock on a temporary layoff under the Employment Standards Act. Because under the Employment Standards Act, a layoff typically becomes a termination after 13 weeks. There's a couple provisions that can extend it, but the typical rule is 13 weeks. And the impact being that after those 13 weeks, there's a trigger for the requirement for the payment of termination pay and severance pay. So there is benefit to keeping employees on the payroll, either at that full salary or a reduced rate even. Now, with the reduced rate approach, that's not eliminating all risk. And there are some issues with respect to recalling employees at less than their full-time wages that we need to consider. Can we jump to the next slide? And the main risk we see when we're looking at, paying someone less than their regular salary is a claim of constructive dismissal. And you might have already heard some discussion about this in the news initially when COVID-19 related layoffs were taking effect. Basically, a constructive dismissal is when a party to an employment contract unilaterally changes a fundamental term of the relationship. In this case, that would be the salary. It was first being discussed in the context of layoffs as absent a clear term in an employment contract, an employer doesn't have an implied right to temporarily lay off staff. It might be permitted under the Employment Standards Act, but it doesn't relieve an employer from a potential civil claim and wrongful dismissal suit. More recently, we've been hearing about the potential for constructive dismissal claims where an employee is compensated at less than their pre-crisis earnings, such as a situation where they may only receive 75% covered by the subsidy. Now, in these cases, there is risk, but there are also a number of very unique circumstances right now that need to be considered. And how courts will consider the impact of the pandemic on the reasonableness of employers' actions remains to be seen. But there's certainly arguments to be made regarding an implied ability to lay off in these situations. In any event, though, this risk can be reduced by ensuring that the financial impact on employees is minimized. And this can be done by providing an additional top-up over and above the 75% wage subsidy. And this really is in line with the government's intentions for the program as well. Now, typically constructive dismissal isn't found unless there's also a decrease of around 10% or more in annual salary. So providing some level of top-up, as well as reassurances as to the limited time period of the reduction, can go a long way to reducing the potential for a claim. It should also be noted there's an obligation for an employee alleging constructive dismissal to mitigate their damages, which means they have an obligation to try to reduce their losses. And given the current economic situation, attempting to find new employment may not be the most appealing of situations. So then let's talk about a situation where we actually have gone ahead and brought employees back now. Let's spend a couple of minutes talking about some of those issues that we might run into once they're coming back into the workplace and any challenges we have there. And go on to the next slide, please. Oh, got it there, perfect. And one issue we're seeing is employee refusal to work. And this can arise for a number of reasons, and each of them brings its own considerations. The first one I want to go over is a refusal to work on the basis that the employee feels it's unsafe for them. And this can trigger a formal work refusal under the Occupational Health and Safety Act. In such a case, you'll need to ensure that you comply with your obligations under the Act for a work refusal. And that involves removing the employee from the allegedly unsafe work and going through the investigation process. Your investigation initially involving the Joint Health and Safety Committee as the process progresses. And depending on how it escalates, the Ministry of Labor can be involved as well. And inspectors have been responding to these issues in a timely manner still. Move on to the next slide. Now, there may also be non-safety related measures that lead to the hesitancy of an employee to return to work. In some cases, these may trigger obligations under the Human Rights Code. In those cases, you'll need to ensure you comply with your duties under the code by engaging in the accommodation process with the employee. This could include considering modifications to the work environment for a temporary period, maybe changing hours, looking at alternate work arrangements in terms of location, i.e. continuing work from home, or other measures, right? We're going to treat this as we would any other accommodation request in the normal course. It's important not to forget at the same time that these same issues might actually trigger an entitlement to one of the new leaves that have been established under the Employment Standards Act. We have declared emergency leave or infectious disease emergency leave under the ESA that are new and that were really been highlighted since the COVID-19 issue has taken hold. If an employee falls within the criteria for eligibility for one of those leaves, they're entitled to an unpaid job protected leave of absence, and they can't be penalized for taking that leave. Next slide, please. Now, we can't finish up without stating that even when restrictions are lifted, we're not looking at returning to business as usual immediately. The provincial government has made clear that there are expectations with respect to reopening the economy. And they put out guidance documents with this in this respect. We have industry-specific workplace directives that have now been released, and these state the Ministry of Labor's expectations for the provision of a safe workplace, and the specific measures that are in place for each industry should be reviewed and implemented by employers. There's also the continued presence of public health directives relating to social distancing and other transmission reduction measures. These bear the force of law, and they need to be included in businesses' plans for continuing operations. Now, there's a lot of guidance out there right now between all these various sources, and that can be a double-edged sword. There's certainly a lot to review and a lot to comply with, but there's also a lot of resources that are becoming available to get it right. So just take the time and do that due diligence to review what's out there, and don't hesitate to ask questions of experts if you're unsure about how something's going to apply to your business. Next slide, please. So that's where this leaves us. With potential eligibility for the wage subsidy, employers should be looking at the status of their operations and figure out how that eligibility could impact past decisions such as layoffs, and how it informs our next steps in terms of workforce planning and planning for ramping up business. If there's challenges that arise in returning employees to work or in keeping operations going with those employees, it's important to be aware of your rights and obligations, whether they're occupational health and safety, whether they're with respect to the Human Rights Code. And don't be hesitant to ask questions of experts in those cases. These can be really particular issues, and the devil really is in the details. These are unique times, and the regulatory framework is rapidly changing. We're thankful to actually have a regulatory framework now. It was a little touch and go while we were trying to advise on the basis of daily press releases at the start, but we have some guidance now. And there are a number of practitioners out there who can help you navigate it. So don't be afraid to ask questions. It's a rapidly evolving situation. Stephanie, anything else?
Nope, nothing for me to add.
Thank you so much, David and Stephanie and Dave, for your wonderful presentations, very thorough. And I know that the audience, and we appreciate you taking the time today. We have about 20 minutes left. We're gonna dive into questions. If I could just remind the panelists to turn your mics and cameras on while we do the Q&A portion. We've received a number of questions. We're gonna try to tackle as many as possible. I'm gonna start off with Dave Ahern from KPMG. We have a lot of questions on the rental assistance program. So first up, are there incentives to make a landlord want to participate in the program itself?
I suppose over and above the fact that the landlord can get maybe 50% of their rent covered, guaranteed from the government, that's pretty much it at the moment. There's no incentive, there's no legislation forcing landlords to actually go ahead and take this on. So it's pretty limited from that point of view.
Okay. Do you know what, by any chance, if the government's considering moratoriums on evictions?
Again, we know that a lot of lobbying groups have actually, have put that forward, but to our knowledge at the moment, there hasn't been there's nothing concrete on that at the moment, unfortunately. But I know there's a number of groups have actually made those representations, but to say if there's anything going to be clear in that, it's just too early to tell at the moment.
Yeah, we have ourselves, because, the program still has to be delivered. So it's a very, very precarious time for a lot of businesses. We got a question on the chat. I don't know if you can address this because I don't know if this information is available yet. Do we know how the government or how a non-essential business to qualify for the rental programs will be determined? Is it the landlord that's making this determination, or is that information available?
Yeah, again, and I know this is going to be frustrating for a lot of people, but there's very limited information out there. I think, how to apply is going to roll out, as I said, through the CMHC. I'm sure, a landlord is not going to be able to determine what's an essential, non-essential business. That's going to fall under how I think that's been classified today. So if you're deemed a non-essential business today, you're going to be deemed a non-essential business for this. I don't think that the terminology can change or the qualifications can change on that front.
Yeah.
It's going to have to involve, again, while the details are not there, just thinking through it, it's going to have to involve, both the tenants and the landlords coming together in order to make this application on their behalf. Because, one, we have to determine what's a qualifying landlord, and two, does the tenant actually qualify under the various parameters that have been set out as well. So it's going to have to be the tenant and the landlord working together, but ultimately it's going to have to be the landlord that makes the way it's currently drafted and the information that's currently there. The onus, unfortunately, from a business side standpoint, is going to be on the landlord to actually make that application.
Okay, thank you. Stephanie, we have a question. Can you speak about the 10% and 75% wage subsidies, and how can this work for seasonal workers who are just bringing back their staff?
Sure. Just for Roland to note, I'm not able to put my video back on, so I apologize that you're hearing my voice floating around out there. Yeah, so as I mentioned, there I am, thank you. Certainly for the CEWS, so the larger wage subsidy program, the federal government has made it clear that it can apply to new hires. So I do see that as potentially applying to a seasonal worker that you're bringing back. The one caveat is if they haven't been working for some months, so perhaps they don't work over the winter and they don't have any pre-crisis remuneration in order to compare with from January to March, you would be limited then to claiming 75% of what you actually pay to them. So it might not work out to quite the same as it would work out for an employee who had been working before the pandemic, where you can compare to that the remuneration that they were earning in January, February up to March 15th. But you would at least be able to claim something if you're bringing a seasonal employee back on payroll now, because that is what you normally have done.
Gotcha. Okay, thank you very much. That's helpful. Dave, a question on the rental assistance program. Do landlords still require to have a mortgage on their property to apply for this or to qualify for this program? Dave, you might
Dave,
have
you're
to
on
unmute
mute.
yourself.
Apologies. Do you think I'd get this technology right at this stage? At the moment, the way it's drafted at the moment, and it's obviously going through the CMHC, that yes, a mortgage has to be there. However, they have, there's been various statements from both the Ontario government and from the federal government and from the CMHC that people without mortgages, that they will be looking to put a mechanism in place that if there's not a mortgage on the property, that you would, that they would be able to participate, and again, on behalf of for the tenant. But again, unfortunately, there is a lack of data again on how that's actually going to work. Again, but this is something that we do expect that there will be a lot more detail on in the coming days.
And it's something we're pushing on very strongly from the OCC standpoint, because from a tenant's perspective, it's irrelevant whether the landlord has a mortgage or not. We want to be treated fairly, and that should be the case.
Thanks, Rocco, and thanks, Dave. I appreciate that you're presenting and answering questions on a subject area that is very challenging as there's limited information. But I think there's so much information and so many new announcements that it's difficult for people to keep track. So it's very helpful to have conversations like we're having today.
Yeah, and I was just sorry, Michelle. I would just add as well that, along with a number of the other programs that were released, what they actually turned out, looked a lot different at the end. I think, in fairness to the federal government and to the provinces, they are trying to solve an issue. It's a complicated issue, and there's a lot of nuances to it. And I think, when they rolled out previous programs like the Business Credit Availability Program, what that looked like in the first few weeks versus what was actually rolled out in the end was actually quite different. I think they did listen to people. They did listen to, now it's not going to be the panacea for everybody, and they won't be able to take care of everything. But, I think they have shown, and they have moved quite quickly, to be fair, from a government point of view. Again, ideally, it's not perfect, but I do think that they are looking to address a number of the concerns that actually have been raised. So I just want to make sure that people are aware of that. And, I think where this rent subsidy does end up, in my view, and it should look a bit different to what we've spoken about today.
Great, thank you for your comments. I appreciate that. Stephanie or David, I don't know which one of you would like to address this. Is there any news of the subsidies that are currently available from the federal government, if they'll be extended, especially the wage subsidy?
Haven't heard anything yet. It is possible for the government to extend the CEWS past June 6th, up until as far as September, but I have not heard anything yet myself that they intend to do that.
Yeah, and I suppose that some of these things, I mean, with it's promising signs that the Ontario government announced certain businesses can reopen or are able to offer curbside pickup if they have an exterior facing door. So I think it's probably a wait and see kind of situation for those programs.
I would think so.
Yeah. Dave, the federal government announced the rent program, and then the province followed swiftly with their program. Do you know how, can you elaborate on how these two work together? Or I think there's maybe some confusion out in the employer community about nuances between the programs or what it means. And don't forget to unmute.
Yeah, apologies. There is one program. I think that's just to be clear on how it's written. Yes, the federal government came out. It's going to be administered by the CMHC. However, each province is going to work within each province. So the initial guidelines were set out by the federal government, and then each province in turn is going to add their nuances to it. Now, we tried to, on the presentation today, try to overlay, as much as we could from the Ontario perspective. There is slightly difference, and I know businesses on the phone may have operations in other provinces as well that might be looking to apply, but the other provinces, in theory, could have different qualifications in order to go to access the program. But it is being run through, say, from an Ontario point of view, there's one program, and it's the Ontario program. I think is the way to view it.
Okay, thank you. That brings good clarity for folks on the line. Stephanie, are part-time contractors eligible employees for the Canadian Emergency Wage Subsidy Program?
Yeah, that's a good question. We have to be careful about the way we use the word contractor. In order to qualify for the wage subsidy program, the individual has to be an employee. And so, we know there are a variety of arrangements out there where sometimes people are retained as independent contractors. Whether they should be or not is another question. But it is very clear that this only applies to someone who is your employee. But if they're part-time, and they're a part-time employee, they can be included in the wage subsidy application.
Great, thank you so much. I know that there's a lot of confusion when it comes to that. We've heard a lot of different feedback from chambers across the province, and continue to do so, and then bring those concerns to the federal and provincial governments. Dave, and unmute yourself. Do you know do you have any sense of the timing when there'll be more information available about the rent subsidy program? I'm sure people are eager for details.
Yeah, no, I know people are. We are ourselves as well as advisors. I think, the initial, the initial communication was that they were going to look to roll out this program mid-May. Now, given we're only a week away from that, it's probably maybe unrealistic that this program will be rolled out in mid-May, but we would expect some further clarity over the next 7 to 10 days. And unfortunately, that's all I can say at the moment. Like, I would urge people to review, to go on, to view Canada.ca, to go onto the CMHC website, to go onto the Ontario provincial website. They are updating those. Typically, it kind of gets updated maybe on a Friday afternoon. So that's when the announcements kind of tend to come out. But we would expect something in the next 7 days, certainly.
Super.
But
terrific.
Dave, the key thing to keep in mind, and it's cold comfort because people are making tough choices every day. But however it gets reorganized, the one piece that is, I think, most strongly committed is that whomever is going to apply, it's going to backdate to April 1st.
Yes.
Again, cold comfort because most small businesses have effectively run out of cash, and they're running on credit cards, and they're hitting up relatives, and they're getting more indebted. They don't want to be making decisions on fairy tales. They need real answers. And to your point, the government is moving fast by governmental standards. Unfortunately, it's not necessarily the speed of your rent payment.
Yeah. No, that's all fair. That's all fair.
Thanks, Rocco. Stephanie or David, can an eligible employer claim the wage subsidy for an employee that the employer hires back and pays retroactively?
Yes, that is something that has been now been made quite clear. They want you to be able to put people back on payroll and retroactively pay them back to the date they were initially laid off, if they had been laid off since March 15th. And to be able to claim the subsidy for those individuals. It is clear you have to do that before you apply for the subsidy. So for many employers, they still face a cash flow problem where they would be happy to claim the subsidy and pay their employees, but they don't necessarily have the money available to make the payments and then claim the subsidy. So that's still a bit of a challenge for many, but it is clear you can retroactively put them back on payroll and pay them and then claim the subsidy.
Okay, great. And then one follow-up question this was one of the questions we received yesterday. We're a real estate brokerage. Our revenues are based on work done months ago. Our dip in revenue may not catch up until July. Is there opportunity for us with the wage subsidy?
Yeah, certainly that's something they'll want to speak to their accountant or tax lawyer about. But there are employers who kind of fall through the cracks and don't qualify. So if that brokerage's revenues do not drop in March, April, or May in a way that meets the 15% or 30% condition, and they don't see the drop until July, at the moment, July would be too late. And so it sounds like they would not be eligible.
Stephanie, my understanding was that you could use both accrual or cash accounting to determine it. So could that be done, again, working with their accounting professionals to manage it on an accrual basis?
Yeah, that's right, Rocco. And I'm not an accountant, so they would have to figure out, when the question talks about not seeing the dip until July, do they mean cash? Do they mean accrual? But they do have the choice. So if on one of those bases they can show that they have the decline, then they might be able to qualify. But yeah, they should have that discussion with their professionals.
Great, thank you. And one last question before I turn it over to Rocco to wrap things up. And to our friend at KPMG, commercial property rental assistance. The question is, does a private mortgage count, or does it have to be with a bank? And I'm not sure if those details are available yet.
No, again, details aren't available, but I think it's similar to the question earlier, is if there's no commercial mortgage, I think, they will be looking at all instances to help tenants to apply under this program, whether there's a commercial mortgage there or not. Again, unfortunately, the details that have only been made available, or if there's a commercial mortgage in place. I think that's unfortunately how I can sum it up for now.
Okay, thank you so much. David, Stephanie, Dave, thank you very much for your participation in today's webinar. We really appreciate your time and your insights. Now I'm going to turn it over to our President and CEO of the Ontario Chamber of Commerce, Rocco Rossi.
Thank you all for participating. Thanks to our experts for giving us the answers that they can and pointing out where answers are still needed. And that's where we step in and have been pushing hard. Remember, when the wage subsidy program was first announced, they were talking about only 10%. And it's moved incredibly. I expect the same will happen with the rent program, but we know that cash is king and that you need clarity. So please help us in that advocacy. Thanks again to Canada Life and Chambers Plan for helping to sponsor our series. Next week, you're not going to want to miss it. On May 12th, we have 2 webinars, one with Minister Mary Ng, Economic Development and International Trade, and then followed by a look at Canada's supply chain, its challenges during and beyond, with Sean Finn from CN Rail. In the meantime, stay safe, phone, email your mom for those who still have them, and for those who don't, they're in our prayers and in our thoughts. Stay safe.
Thanks, Rocco.
Thank you very much.
Thanks.
Thanks, everyone.